Hello, everybody. This is week 6 of legal research. My name is Lauren Gerhart, and we will be talking about my law review article this week, probation and eligibility. So let's get started. So first, we're going to be talking about the background, the importance, and my methods of research. So the problem that I address in the article review is probation and eligibility for young offenders. So the article I found was Probation and Eligibility, A Time for Reconsideration in Kentucky by Brady Grove. The issue of prohibiting probation for young offenders comes from the KRS statute 532.045, Section 2, which restricts probation for minors who have been convicted of sexual crimes. The statute lines out the criteria considering the intentions of the interaction and the use of a weapon. So the issue is important in Kentucky law because of its approach to the safety and rehabilitation of community members in Kentucky. A statute to encompass juvenile reform has sparked debate on whether this serves as a blanket solution or if it disregards rehabilitation. So my methods to approaching this topic was pretty straightforward. I have a particular interest in criminal law. So I first went to the KRS, Kentucky Revised Statutes, to look at relevant topics that have direct statutes relating to them within criminal law. Then I searched through the University of Kentucky Law Review to find something on this topic. This is where I found the law review article. I used the terms such as probation, rehabilitation, to find what I was searching for. I searched for cases once reviewing this article that revolved around this issue, which is when I found the case that I will be discussing shortly. So we're now going to be talking about the summary of the law review. So the main argument in this article is that whether the statutes regarding probation and the ineligibility is unconstitutional, and whether it considers age, maturity, and rehabilitation in young offenders. Grove, the author, critiques that the penalty is disproportionately harsh and emphasizes the need for judicial discretion and individualized sentencing. The key legal arguments presented in the article regard the Eighth Amendment. He argues that the complete prohibition of probation constitutes cruel and unusual punishment by not taking into the account the reduced culpability and greater potential for rehabilitation. Grove also points out the U.S. Supreme Court precedents to emphasize the need for individual sentencing. So, case application and court relevance. So, the case that I have applied to the article is the case of Boyer versus Commonwealth. This case surrounds a 15-year-old boy who was convicted of multiple sex offenses. He was sentenced to 15 years in prison, and on his 18th birthday, he was denied probation and ordered to be transferred to the Department of Corrections from the Department of Juvenile Justice. And at age 21. And before he turned 21, he applied for probation yet again and was denied, citing KRS 532.045. So the article relates to the case because it challenges the statute applied in the case. So the article argues for legislative reform so that individuals like Boyer have the opportunity for rehabilitation due to their developmental immaturity and ability to reintegrate into society. It also points out Section 2 of the Kentucky State Constitution on arbitrary state action by imposing disproportionate penalties on young offenders. Though a Kentucky court may find the article persuasive, its authority does not equivalent to the binding authority of primary authority, such as statutory law. So, comparing secondary versus primary authority. So, law review articles, such as the one we discussed, provide commentary and can critique legal principles, statutes, and case law. However, they are not binding. like primary authority. Um, Instead, primary authorities such as case law and statutes establish law and directly enforce the law. There are many strengths for using secondary authority in legal arguments. For starters, it can be used to analyze cases and how certain laws are interpreted within the historical context and compare them to other jurisdictions' decisions and implications. It can also advocate for the change in the law, uncovering gaps and inconsistencies in existing case law and statutes. However, there are some weaknesses. Obviously, secondary authorities such as law review articles are not binding authority. Therefore, courts do not have to take what these articles say into consideration when put up against statutory law. It also could have a potential bias in it, depending on the researcher and the information that they have researched. So, as a conclusion, the law review article, Probation, Ineligibility, A Time for Reconsideration in Kentucky, makes a great contribution to legal research as it critically examines existing statutes regarding the problem for young offenders and probation. It challenges KRS 532.045 and its failure to take into account developmental differences between adults and minors and their potential for rehabilitation. A takeaway from this research that I got was the importance of balancing the public safety and reforming juvenile justice. Thank you.